All right, talk to your attorney about it.
Judge, I think, man, we're going in circles. You're not to be disrespectful to the court.
Let's roll, nerd.
This is the court restoring order. When an attorney states on the record that communication is broken down, the judge doesn't debate it. She acts. New counsel is appointed, the case is stabilized, and the defendant is protected from making uninformed decisions alone. Let's be clear about what happened here. The judge did not punish confusion. She prevented it from causing irreversible harm. By appointing new counsel, the court ensured the defendant would have proper guidance before making any plea decision that could affect years of his life. The takeaway is simple but critical. The courtroom is not a place for circular arguments or emotional negotiation. It's a structured legal environment where clarity, preparation, and communication matter more than anything else. Now, we want to hear from you. Do you think the court handled this fairly? Should defendants be given more leeway? Or is firm control necessary to keep justice moving?
Been fired up when their clients, it's usually just an old timer representing defendants back in Prohibition, and can't stand how these darn kids keep talking in circles. It is terrible for them, but comic relief for us. And speaking of relief, what if I told you I could alleviate the strain of online predators gaining access to your information? Well, today's sponsor, Aura, is that. And like and subscribe, set your notifications to all. Let's roll, nerds.
You just got to make her better to find it.
Pardon me? First row, ma'am, please just have your names.
So, Justin Cotton.
Yes, ma'am. Judge, now he wants to approach you talking.
Oh, no, just give me 1 second, Mr. Cotton. I'm sorry.
A little longer than a few minutes later.
You get wherever you want to hear it, Judge.
Yes, what is happening?
The state made an offer of 8 years. He is declined.
Oh, no. Here's the thing. You all are doing plea negotiations. I'm not supposed to know what the offer is because plea negotiations are confidential. So my only question is, where are we on this case?
Judge, the state has extended an offer to Mr. Cotton. He is at this point declining that offer. I did make Mr. Sherman aware that currently he's alleged to be a repeat offender, but most likely we will be re-indicting him absently to allege the habitual offender allegation. So that's the only potential change that might happen. I don't think it'll derail necessarily the settings, but we might have to re-indict just for that purpose.
All right. So what do you want to do, Mr. Cotton?
Your Honor, I just came from Nueces County. I have paperwork. I just signed 5 years deferred adjudication over there. Similar charge.
Here's the thing. I don't have any.
I understand.
Don't negotiate with me, right? I'm not the person you negotiate with. The person you negotiate with is the state through your attorney. So don't come before me saying that Nueces County or whoever it is gave you deferred and that you want me to do that, because I haven't seen any of the facts in your case. I only know what you're charged with. And once if you decide to enter a plea, or if you decide to enter into open plea to the court, that's when I'll know what you're charged with and the facts behind the case. So as far as you negotiating with me, trying to get a specific deal, this is not the time for that. You understand?
Yes, ma'am.
All right. So do you want to continue to confer with your attorney?
I was the open plea.
All right. Talk to your attorney about it.
Judge, I think, man, we're going in circles. You're not to be disrespectful to the court. He's asked for another lawyer. If he doesn't get it he wants, he keeps on going around.
He said he wants to talk to you about an open plea. So please discuss an open plea with your attorney.
Yeah, I did do that.
All right, then. If he wants to do an open plea, you all need to fill out paperwork.
Well, if I'm angry, it's your fault. Much later.
It's scheduled for today or something, but it kind of all hit me last week and I don't know too much about it yet.
All right. So on this one, let's see if we can get a 45-day reset. September 26th.
Should I put it in paperwork then?
I don't know. May I approach?
Yes.
Mr. Cotton?
Yes.
So I'm having difficulty communicating with him. You see that every time I approach him again, he changes his mind about what he wants to do.
All right, Mr. Cotton, come up, please.
Now he's stuck through, doesn't want another lawyer, which might be a.
Well, Mr. Cotton, please come up.
Default T, this moment right here is where everything starts to crack. The defendant keeps saying he wants an open plea, but doesn't fully grasp what that actually means. An open plea isn't a negotiation, it's the opposite. It means pleading guilty without a sentencing agreement, placing your fate entirely in the judge's hands. That's why the judge keeps saying, talk to your attorney. She's not being evasive, she's enforcing boundaries. Judges cannot coach defendants, negotiate deals, or explain strategy beyond basic rights. Meanwhile, the defense attorney is stuck in an impossible position. Every time he approaches his client, the answer changes. One moment it's an open plea, the next it's hesitation, then frustration, then blame. That instability is a serious problem in court. Ask yourself this: if you were facing serious time, would you want to make a life-altering decision while this unsure? Or would you pause, listen, and let counsel guide you? This is exactly why courts value clarity. Indecision doesn't just slow things down, it creates risk for everyone involved, especially the defendant.
Yes, ma'am.
Just 1 second. What page was Linda Corey's slide on?
Yeah. For the second week.
Yeah.
Okay. Thank you. All right, Mr. Cotton, what would you like to do?
I'm not. I'm just trying to comprehend everything. I'm a little slow, like just trying. I'm not like the court system, but
Oh, no, here's the thing.
I'm not trying to fire him. He's telling me to fire him. That's I'm saying that's I'm not doing that. He's saying he don't want to represent me.
All right, do you wish to represent him, yes or no?
No,
All right, then you're excused. All right, just have a seat and we'll get you another attorney, okay?
Today?
thank you, Your Honor.
Yes, we'll get you an attorney today.
Okay, thank you.
You're welcome.
Ma'am, because I
No.
no.
We're gonna get you an attorney, okay? Just have a seat.
I'm here. Yeah.
Just have for him.
Your father wants to talk as well. All right, ma'am, what I'm going to do is set your bond in the amount of $500 on $1,500 and get you for a video review.
This is the court restoring order. When an attorney states on the record that communication is broken down, the judge doesn't debate it. She acts. New counsel is appointed, the case is stabilized, and the defendant is protected from making uninformed decisions alone. Let's be clear about what happened here. The judge did not punish confusion. She prevented it from causing irreversible harm. By appointing new counsel, the court ensured the defendant would have proper guidance before making any plea decision that could affect years of his life. The takeaway is simple but critical. The courtroom is not a place for circular arguments or emotional negotiation. It's a structured legal environment where clarity, preparation, and communication matter more than anything else. Now, we want to hear from you. Do you think the court handled this fairly? Should defendants be given more leeway? Or is firm control necessary to keep justice moving?
Yeah, so she's other up where I'm so I'm sure. Well, so I've been here since
All right.
1:30. That's not. Yeah, I think the court.